Okay, today is March 4th, 2013. This is Children in Justice, and we're beginning the class. And at the beginning of the class, I'm looking at two of the students' registered risk assessment scale submissions, which were for Learning Project 2. Everybody submitted their Learning Project 2s, and I'm eager to look at them, and I only looked at Nicole and Philip so far, and I'm going to grade them later on in the week. So what we're doing right now is we're going over the scales that were submitted, and trying to help everyone understand some of the trickier sections of the scales. Now, we were looking at Nicole. She was grading or rating criteria 1, degree of force, and she put the X in the no physical force box, and she made her comments. Her comments, that box, is designed to give us the gist of some basic information that caused her to conclude that force was not used. She writes, registrant lured 5- and 7-year-old boy into his home by asking them if they wanted to play Nintendo. Okay, that does not involve force. That is a proper clip from the, or segment from the discovery and the reports that supports her conclusion. She also properly said source, Fair Lawn Report 1994. And I'm suggesting that you might want to get even more precise and put in page 12 or 16 or wherever it appears in the Fair Lawn Report from 1994. We went over the Registered Risk Assessment Scale very quickly at the end of last class. Let me talk a little bit more about the scale and why it's important. When someone gets out of prison or is placed on, are you raising your hand?
No.
Okay. When someone gets placed on probation or they're released from prison, the prosecutor in the county where they're going to live, where they're going to move from jail, or if they change residence on probation, that prosecutor has to look at that offender and all of his prior history to assess his level of dangerousness and future risk to reoffend sexually. We're not concerned about whether he might reoffend by committing a burglary or commit a general crime. This is about sexual dangerousness or sexual reoffense. So one way to do that, to give us a sense of how dangerous this person is, whether they're going to reoffend or not, is to use this risk assessment scale. Now remember, I did tell you last week that the Megan's laws, or the sex offender registration and community notification laws, arose from the death of Megan Kanka, who lived in Hamilton Township, and she was murdered by a sex offender who lived about a block away in her community. And her mom, Maureen Kanka, had argued that if she had known that these sex offenders, there was more than one, but the one that we're concerned about was Jesse Temendequaz, the person who murdered Megan. Had she known that there were sex offenders in her community, she could have taken positive steps to protect her daughter. Maybe tell her to stay away from that house, talk to her about dealing with strangers, or talk to her about dealing with people, adults in general. She could have taken action to protect her daughter. And she felt, as many did, that the law ought to have a process whereby the community is notified about sex offenders who live nearby. Now, Maureen and many advocates for Megan's Law and similar laws would have loved if any time a sex offender got out, you'd tell the people in that neighborhood and beyond. Now remember, 1994, the internet was just starting. There wasn't an internet for the general public, so to speak. So the perception was that you would go out and knock on doors or hand out flyers or have community meetings and the like. But, you know, Ms. Kanka and all advocates for Megan's laws and sex offender registration notification would have been delighted if it was a simple process. A guy gets out of prison, he moves to Main Street in Clifton, and you notify everybody in his neighborhood. Simple. But it doesn't work that way, because these cases went to the courts of New Jersey and the federal district courts. And the sex offenders argued that this notification process violates their right to privacy. They did their time, they served their sentence, they were punished, and they shouldn't be punished again. And they relied upon, among other constitutional provisions, the double jeopardy clause of the Constitution. New Jersey has one and the federal courts have one. And that says, listen, you can't be punished twice for the same crime. And they're saying, in part, we were punished. Now we're getting out. We want to live our lives. We served our sentence. You're punishing us again. In the worst form of punishment, you're outing us. You're making us vulnerable to the wrath of the community here. There were other arguments, including the right to privacy. Look, we've done our sentence. We paid our debt to society. And we have a right to live peacefully and quietly without the government interfering in our lives anymore. So not only does this violate the double jeopardy clause, but it also violates our fundamental right to privacy. And although there is no right to privacy in the United States Constitution, the Supreme Court many years ago interpreted the Constitution to have created a right to privacy. It kind of emanates, I don't know. Ask Justice William O. Douglas, who wrote that opinion. And it's a very important opinion because the right to an abortion arises out of the right to privacy. And so this right to privacy and the criticism of the Supreme Court in announcing a right to privacy some many decades ago, in the 1970s, is controversial. But for our purposes, it's good law. It has lasted many, many decades. And there is a right to privacy. And these sex offenders said, listen, you're violating our right to privacy. You're telling the community about personal details of our lives. And they went to the federal courts and the state courts on that theory as well. Well, the New Jersey courts, and later the Third Circuit Court of Appeals, that covers New Jersey, Pennsylvania, and New York, they issued opinions. And they basically said, especially the New Jersey court, they said, look, if you're going to go out and tell the community about sex offenders, you have to do a balancing act here. Because there's two really important interests here. The right to the community to be safe, right? The right of children to be safe, the right of children to have justice and live peacefully, unencumbered and unintruded on by sex offenders, and the right of the sex offenders to live peacefully and quietly, and to not be punished again. So we have to balance things here. Now, the first order of business was this double jeopardy thing. And the court said, well, there's no double jeopardy, both courts. And the reason there's no double jeopardy is because this isn't punitive. It's an administrative law. It's a registration law. It's not designed as punishment. Now, does it have a punitive effect? Yes. Are there sometimes laws that are administrative that have a punitive effect that the courts have said, well, even though it was designed as administrative, it has a really, really big punitive aspect to it, and that kind of outweighs the administrative need. So simply because it is administrative, we want people to go downtown, sign a piece of paper, get their picture taken, and go home. Okay? It's not punishment. Simply because it's administrative doesn't end the inquiry. Does it have a punitive impact? And if it does, is that punitive impact? Punitive meaning punishment. Because that's what double jeopardy is about, getting punished twice. Is this punitive aspect to a largely administrative law so overwhelming that it blots out or overrides the administrative part of it, and in essence, it really is punitive? And the court did that, and they said, no, it's administrative. You go downtown, you fill it out, and it doesn't have such a significant punitive impact that we're going to rule that it's unconstitutional. So that's out of the way. Now all that's left, there were other issues, but the most important issue was right to privacy. Okay, they lost ex post facto, and they lost double jeopardy. Okay, they also argued ex post facto. That's another one. We don't need to talk about that. They lost double jeopardy, and the sex offender said, well, what about the right to privacy? And the court said, that's a tougher one. That's a tougher one, and that requires this balancing process. In order for this government law here to pass constitutional muster, in order for Megan's law to be constitutional, it has to balance the sex offender's right to privacy with the community need for protection and safety. In order to do that, get into the scale, in order to do that, the notification has to be narrowly tailored to that sex offender's risk. What that means is you have to treat each sex offender differently based upon him, and I always use the male pronoun for this class, okay? Although there are women sex offenders, they are dwarfed by the number of men. This sex offender, you have to look at him and his history. So if you're going to violate his privacy, he has to be the kind of person who requires notification. That he's such a high risk, such a risk to the community, that now the right to privacy gets outweighed by his risk. Okay? So everybody starts with this right to privacy. Okay? And we have to show with each individual sex offender that their level of risk makes the level of risk kind of tilt the scales now, so privacy for this guy becomes less important and public safety becomes more important. And the way we do that is doing the risk assessment scale for each separate guy. So if he's a low risk, well then his right to privacy has not been outweighed. And he's got the same rights to privacy we all do. Now when you get to medium and high risk, well then the scales are tilted differently. So that's why we look at risk of reoffense. Because the courts of New Jersey and the United States Courts of Appeals for the Third Circuit have said notification has to be narrowly tailored. Okay, narrowly means very highly focused on this guy in this community. So we came up with this scale. And the scale is a great starting point. It's not the end of the issue. The judge can look at expert witnesses. He can or she can make her own decision. But most judges defer to the scale unless there's something unusual about the guy or the case or the facts. So that's where we come in. We have to apply the scale. And in this case, what was the sex offender's initials? JW? Is that right?
No.
WJ? I know some of the redaction didn't work. Thank you for alerting me. We're going to fix that. But if you make him a tier 3, he's got no right to privacy, so it doesn't matter, right? So let's root for him 3. No, I made best efforts. His name escaped. We'll fix it. WG? Is that it? WJ? WJ. Okay. WJ. So we want to check out WJ's risk. Not everybody's risk. Not sex offenders generally, but WJ. So what do? We get all the history about WJ, not just his sex offenses, his whole life's history. That's what makes Megan's Law and people who work in this unit find that it's such difficult work. And it's very paper intensive. Thankfully, in 2007, I was able to get grant money to completely digitize the unit, which if there was any unit in the world that could benefit from PDFs and digital files, it was the Megan's unit. Because we were surrounded by filing cabinets. Because when you have over 1,100 registered sex offenders in the same county, for some reason, we were number 2 in the state. We're like number 11 population, but number 2 in the state. And we were surrounded by filing cabinets. Now we're just surrounded by the low hum of computers. And all of the stuff is scanned. So now we have to get all of his records, which you had, all the stuff about WJ, and figure out his level of risk to see whether those scales, whether his privacy takes a backseat to public safety because he's a high risk. That's what this is. So when Nicole looks at degree of force, she's looking at it for a reason, 2 reasons. These top 3 categories, force, contact, and age, they serve a dual purpose. Number 1, there is a correlation between people who use force and risk of reoffense. Every one of these categories, 1 through whatever, have a basis in research. And what I mean by that is, smart people have studied what a high-risk sex offender looks like. And sex offenders who use crowbars and guns and bats and use violence and weapons are more likely to reoffend. This kind of stuff is not that difficult. You just need a lot of data, and you need a lot of people to apply that data, and you have to do it in a way that's objective and reasonable, and has control groups where you're not mistaking what you're doing and drawing unreasonable outcomes. I never took statistics. Some of you take that. People tell me that at the college level, statistic is like, you know, being tied to a killer and whipped. It's a horrible course. In any event, some other folks did the work for us, so you don't have to do the statistics. We know that when sex offenders use weapons to commit their crimes, they're more likely to reoffend than the guy who didn't use a weapon. We're not giving the guys who didn't use a weapon a gold star. This 0 doesn't, you know, have our seal of approval. It simply means that, well, they didn't use a weapon, so on that category, they're a lower risk to reoffend than the dude who uses a weapon. There's a twofold thing here, too. The other thing is, we want to promote community safety. The most recidivistic sex offender of all is the flasher. Okay? They reoffend all the time. If you go look at the research and you say, what kind of sex offender is the most likely to reoffend, it's the flasher. But are we going to dedicate all our resources to run around notifying the community about flashers? No. We want to make sure that when we do this scale, that not only do we capture the risk of reoffense, but we also capture the quality of the harm. If this guy reoffends, what's going to happen to the person who he offends against? You know? And so the top three categories not only address risk of reoffense, they also address the quality of the harm that would arise if they reoffend. So we want to make sure that notification goes out for people who are dangerous. So you'll notice here, these three, although they all have a correlation to risk of reoffense, they also have to do with how intrusive and how violent the outcome would be if they reoffend, right? Little kids penetrated with weapons. Right? These are the three highest rated categories. That's why you multiply by 5. Because we want to make sure that this scale captures the most dangerous recidivists, not just the recidivists. Recidivist means person who's going to do it again, right? The most dangerous recidivists. So there's 2 goals here. So that's why we rate it by a power of 5. So back to Nicole. No threats. She gives a short snippet. She tells us where she got it. Number 2, degree of contact. The research tells us that people who penetrate and rape are more likely to reoffend than those who fondle. Again, we're not giving gold stars to the fondlers. We're simply acknowledging that those who forcibly or without permission penetrate another person are more likely to reoffend. And that's the most aggressive kind of sexual assault, when you penetrate somebody. The most intrusive kind of sexual assault. So, Nicole said, let's take a look at the case. Well, he fondled a 14-year-old girl in a hotel room. He grabbed the breast of another 14-year-old girl and engaged in penetration with a third 14-year-old girl. And here's another lesson from Nicole's work here. You got three 14-year-old girls. Well, what do you put here? One was a fondler, the other one was a fondler, one's a penetrator. You pick the penetration. You pick the fact that's most adverse to the sex offender. Okay? And here, one of them was a penetration, so we score him for the penetration on this criteria, and the other ones are not that relevant. It's good to put that there, nothing wrong with that, especially for your notes, if you're ever in court, or you're talking to a supervisor, or you need to refer back here. You know, well, there were 3, but one he penetrated, the other 2 he fondled. It gives you a bigger picture and a better picture. I would like, okay, this had nothing to do with grading you, but if I was going to court with this, I'd like to know what he did. Was it fellatio, cunnilingus, was it intercourse, was it digital, fingering, object, whatever. But this answers the question, and I know where to find it. The ADTC reports from 98 and 99. So there's your source. Okay? So penetration seems to be properly scaled, and the numbers are proper. The highest risk is 3 times the power of 5 for this particular category gives you 15, and we have 15 out there. Now the last of the categories which address dangerousness and quality of the harm is age of the victim. Now this is a multiple offender. He's offended on multiple times. And something else that I think I addressed in an addendum to my original video is, when I just said it again, you pick the one that's most adverse to the sex offender. So you have, he molested 2 17-and-a-half-year-olds and 1 6-year-old. Well, the age of the victim for this is going to be 6. You're going to take the most adverse fact towards the registry. 2 victims under 13 and 3 victims between 13 and 17. So we're going to take the 2 victims under 13. Now, it'd be nice to know what their ages were, right? Wouldn't it be a 5-year-old and a 7-year-old, or a 12 and a 12? At the end of the day, 5 and a 7-year-old is one kind of molester, and 12 and 12 is marginally different kind of molester. Nevertheless, Nicole did not need to do that. That's not about the success of this learning project, but that kind of precision is a little bit better. So she says where she got it, same thing, Abenel report. Okay?
Question.
Yes.
This scale is used on immediately somebody commit a crime. This scale is used for them, right?
This scale is used immediately when someone commits a crime?
Yeah, either the first one, the second one, the third one is used on each crime that is.
Oh, I got your question. Yeah, well, you know what happens? Some of these things happen before Megan's Law. He might have been evaluated in another county, but yeah, every time an offender commits a sex crime and goes to prison or goes on probation, and then is going to be back in the community, you have to apply the scale. Now, let's say he commits a sex crime, he goes to prison for 5 years, he comes home, right? He commits a new sex crime, he goes to prison for 8 years, he comes home, then we do a new scale, and we look at the first, then we look at the aggregate, all the stuff. So yes, you would use it every time a guy is convicted of a sex crime. Good question. Now, so the next part of the inquiry is victim selection. Now this is a critical one and it's an important one. You'll notice it's multiplied by a power of 3. So that means it's important, okay? And we call these categories static. Static's just a clinical word for they don't change, okay? If you molested a 6-year-old, that fact will never change. You molested a 6-year-old. You ain't gonna turn 12 or 15 or 21. That's an immutable fact, it doesn't change. You'll see later at the bottom, you know, where you live can change, right? Whether you go into therapy can change. Those are called dynamic factors. Static and dynamic. These are still static factors. And this is called victim selection. This is, among all of them, perhaps the most important criteria in my book. Why do I say this is the most important criteria in my book? When you look at the purpose of Megan's laws. Say that again?
It's to determine risk. So if you have a community where the age that he normally targets, he would be at greater risk for reoffending.
Right, but we're not talking about age here. You're right, it's to determine risk. It's an important category for us. We want to make sure the community is protected. Go ahead.
How he selects his victims?
Yes, why is how he selects his victims important though? I'm saying the most important thing.
Right, because if he's, for instance, if he's a babysitter and he's more than likely than not gonna offend with somebody he's acquainted to, that's a bit different than somebody who just randomly goes around collecting people off the street, like, oh, her skirt's short, let me grab her.
Right. So who's more dangerous?
The stranger.
The stranger guy. Very good. The goal here is to look for predation. Predation's a conjugation of predatory. It's a word that's formed out of predatory, right? We're looking for predators here. And, you know, if the person offends within his own family structure, what's the point of knocking on doors? He's less likely to offend against strangers. And I'm not saying that that's not something we take into account, even the intrafamilial or intra-household offender. But yeah, the guy who's looking for strangers, like you said, the guy who's driving around in his car or picking on people he doesn't know, they're the most predatory. So this really tells me a lot, this category here. You know, and I don't know if it was this one or the one that I did by way of this example. I think it was the example one. The guy met these girls at bus stops. So the other lawyers saying, well, they're acquaintances. In fact, one of them, he chatted up the girl at the bus stop, if you remember the sample I gave you in the video. And then maybe 2 or 3 days later, he rapes her, right? Well, is this really an acquaintance here? An acquaintance just doesn't mean you just talk to somebody and therefore you're an acquaintance.
Are you about the relationship?
Yeah, well, in 2 days.
He picked her and didn't.
Well, you can make that argument. And what else about that situation where we can make a better argument if we're saying, yeah, what about bus stops? It's a transient population. It's where people go. It's where you find, you know, most of these pimps out there, where do you get these runaways? Well, they don't get them at ShopRite. They don't get them at Willowbrook Mall. You know where they get them? The big bus depot in Manhattan, right? What's that big Grand Central? Port Authority. Port Authority. Where do runaways go? The bus stop, the bus depot, right? Where are kids? Where are travelers? Where are people not from the community? At the bus depot. Yes.
But this also shows a pattern. Like, it can also show a pattern of behavior.
That's right.
Because it can also show, like, if he's doing it every 2 years, then you'll be able to see that pattern when you fill this out.
That's right, and that's why it's important to look at all the stuff together to look for patterns and look for what they call modus operandi or MO or patterns. And you're exactly right. So this category needs to. We need to pay special attention to this category in my book. Household member, acquaintance, stranger. And the research is clear. People who molest within the household are far less likely to reoffend than people who molest strangers. Okay? Like it or not, it's a fact. So, we need to look at this. Now, Nicole writes that this registrant was acquainted with all the victims from the neighborhood he resided in or the school he attended. Source, the Fair Law 1994 reports, the ADTC reports from 98 and 99, and the victim statements of Gina and Eva, 1997. That's excellent. Again, would have liked the pages, but that's okay. What it is, she also gives us multiple sources, right? So we can look at how the kids expressed their relationship with him, you know, how the reports expressed the relationship. Okay, the reports might have played fast and loose with the language that they used. Oh, he was acquainted with them. When you read the girls' statements, they might have said, yeah, I became acquainted with him. I went to the bus stop that day and he told me, hey, are you down with whatever, blah, blah, blah. And wait a minute here, this isn't really, you know, the doctor called it an acquaintance, but now I read how the kid expressed it, and he kept calling me, and he was relentless, and so I went out with him. We got in the car and he threw me in the back seat. That's not even an acquaintance, man. That seems like a targeted rape. Nevertheless, if you gloss over it, it might seem like an acquaintance. They made a date, they were going somewhere, he came and picked me up. That kind of language suggests like a date, where you need to look at all the facts to really make a decision. I had a case where a guy named, this was in, we'll call him Otto, you wouldn't know who he is. This guy named Otto, since passed away, so he's got no right to privacy. Otto lived he was a millionaire too. He had a house in New Hampshire, or somewhere in New England. I think it was New Hampshire or Vermont. And he molested all these boys. And his argument was they were acquaintances when we were doing the scale. And he lived in New Jersey now. And they had top price attorneys came in, and he was an executive for the Domino Sugar. He made a lot of money in commodities, betting on sugar prices, and betting on price of nutmeg and all this stuff. And anyway, now he's living in Jersey. He has this history of prosecution and criminal behavior in New England, Vermont, we'll say. And all these boys, and I said, wait a minute, man, are these acquaintances? And every one of them, this is very common among these kind of predators, every one of them, he invited over to do yard work or to work on a construction project, to do these kinds of things. So I said, you know what, did he really need it? So I called the New Hampshire, whatever town it was, police and state police up there, and I wanted to get a little bit of behind-the-scenes information about this case, because that's not something that the police would put in there, because it has no relevance whatsoever to the crime. Like, was he building something in a yard, or did he just have him digging a ditch and then filling it back in? And it turned out there was nothing back there. There were acres and acres of woods and tangled branches, and it was a sham. It was a targeted offense where he lured these kids in with some BS story about doing work in his yard. You know, then in 20 minutes he was offering him a cool lemonade and come in the house and let's look at porn and smoke pot and drink 151 rum. So, and eventually he built, I called them dorms downstairs. He built little, like, you know, well, sometimes they worked hard into the night and they needed somewhere to sleep, so I built these little dormers. You know, at the end of the day, and they were kids from the neighborhood, though. You know, he's not going to drive to Connecticut to bring kids up there. He went and found kids who lived in the general neighborhood and offered them money to help out at the place. But again, I don't want to overstate the point. I said these kids are, for our purposes, they're not acquaintances. The reason why we look at member in a household, acquaintance, stranger, is to measure their level of predation, how predatory they are. This was predatory. Call it what you want. Call them acquaintances. They're not acquaintances in the general sense of the word, okay? I'm acquainted with the professor on the first floor. You know, I borrowed a stapler from her once. I said, how you doing? I saw her at one of the meetings at the school. You know, I see her name on the Montclair website. She's an acquaintance. Okay, that's a real acquaintance. You know, inviting someone to your house. with the express purpose of eventually molesting them as a predator. So one needs to look behind the labels and the behavior. That's why looking at the statements of Gina and Eva would be a good idea, right? Does that make sense?
Yeah.
All right. Any questions so far? Very good. All right, let's not pick exclusively on Cole. Philip. Let's see what he did. Well, let's compare his findings. No violence. There's consistency. You know what they call this? Inter-rater reliability. That's a fancy way of saying you take two people who do the same scale and see whether they agree. And what do they disagree on? And when people do statistics, when smart people do this kind of work, they have a formula for inter-rater reliability. You have a formula for figuring out where most people are on the same page. If everybody's got wildly different conclusions, you can throw the scale in the garbage. So, I'm not here to pick on anybody. Let's just see how they did. With inter-rater reliability, they agree on no reported violence. Registrant admitted to sexual penetration of a 14-year-old female. Now, did we see a sexual penetration? No, that's right. It's a 14-year-old female. You don't have to tell me about the others. I need sources, though, okay? We need to know where you got that from, but that's all right. Prior conviction with a 7-year-old male. Okay, you both had under 13. You both identified the 7-year-old male. Let's see victim selection. Registrant knew all 3 victims, had a relationship with the female, and babysat the 2 underage males, also known from the apartment complex. A little bit more information than Nicole, and a little bit different information. I like all that information, and I can't get it all in the box. So both of you would lead me to where to find it. Statement from Ava and Gina. Philip gave us the facts. Again, sources, Philip, okay? And everybody else. But the conclusion is the same, right? Mm-hmm. And that's where you get inter-rater reliability. Both Philip and Nicole agree. Number of offenses and victims. Now, the psychometric edit file indicates the registrant had at least 4 previous convictions. Now, here's where we need a little help here, okay? The psychometric edit, that's just the file name I gave it. I think I edited it, but you would have to look at the document and see what it is. I think psychometrics, the name of the company that did one of his evaluations. But so he says, the psychometric, so we have a source here. Psychometric file tells us registrant had 4 previous convictions. And that's nice. But what I may not have been clear about is, number 5 measures what kinds of offenses. Burglaries and strong-arm robberies, sex offenses. And that may be 4 sex offenses. Do you know, Philip, were they 4 sex offenses? Hold on, I'm talking, I can't hear. Let me hear from Philip. I'm sorry.
One of them, I think, was just assault.
Okay, so here's where I might not have been clear enough. And here we want number of sex offenses, okay? And the reason is, again, some of this stuff is very logical, right? You molest once, and you compare that guy to a guy who molested 3 different victims at 3 different times over a period of years. Who's more likely to reoffend, right? Obviously, the guy who molested 3 kids versus the guy who molested 1. So here, we want to measure how many sex offenses. Don't even have to be convictions. How many sex offenses has he been accused of? Go ahead.
Now, what I was confused about with number 5 and number 8 was the Megan's Law violation when he didn't register. I didn't know whether that was under number 5 or number 8. I'll put it under
That's a great question. That's a great question. That's why everybody gets a pass on that stuff, because you wouldn't know that. That's okay. The Megan's Law violation of registration is not a sex offense. What that is when they go register in Clifton, let's say, they have to come back every year, or certain people have to come back every 3 months, and they have to prove that they still live there. Sometimes they stop coming back. They blow it off, or they don't ever register at all. So then we charge them with failure to register or violation of address verification. And that would be an offense. It'd be a crime. It is a crime in New Jersey. But it looks like violation of sex offender statute. But that's not what we're looking at. That certainly is something we're interested in, and your question, you would go here. That's an antisocial act.
I put it under 8.
Good for you. That's good. That's good because it's not a sex offense. What we're looking about here is people who commit sex offenses and how many did they commit. And in this case, there were multiple sex offenses. I by looking at remembering Nicole's, we had 2 14-year-olds, maybe 4 14-year-olds. It was a 7-year-old we know about. So this guy had 3 or more victims in his career. Okay, so that one's sex offenses. Now this one can get a little tricky. Duration of the offensive behavior. According to the TRED update, registering offenses regarding the 7-year-old were between 91 and 93. And with the 14-year-old female, it was over a period of 6 months. And Philip analyzed this very intuitively. And it's very easy to do this, but it's really not what we're looking for. Well, I think what you did, you tell me. I think you looked at the 7-year-old, where am I? Here. The 7-year-old was between 91 and 93, so that was about 2 years for that kid. This kid was a period of 6 months, and you were treating these as separate little molests, which they were. And then you said, well, which is the most adverse to the sex offender, which I told you have to do. What's the worst one for him? The 2-year one. So I'm going to pick 1 to 2 years. Is that kind of what? And that's reasonable, and that's why everybody's, if you're in the ballpark here, not everybody, I don't know what you did, but if you're in the ballpark here, you're going to get credit for it. And I'm going to be very, very lenient when it comes to this. And that's a very logical analysis. But what we're looking for here is, it's even easier than that. You don't even have to do that much work. What you need to do to fill out this category is find from the documentation the first time he ever molested. Whenever that was. And they don't even have precise dates, because kids don't give precise dates. But let's say it was March 1990, we'll say. He molested it. Not this one, I'm making one up, hypothetical. March 1990, he molested a 7-year-old girl. Okay? And he didn't do anything else that we know about. And then in January 2012, he molested a 13-year-old girl. You take the first and the last, and you count the days. Because we're concluding that this guy's been a molester that whole time. We take the first offense and the last offense. And we conclude that that behavior lasted for 13 years, or whatever it is, 1990 to 2012 would be 12 years. So you take the first offense and the last offense, and you count the years. And that would be over 2 years. His sexually offending behavior started in the 90s. And it never ended. In fact, he molested again in 2012. So that's how we count it. Okay? No, not this guy. I made that one up. Now let's look at this guy. See, I don't know here because we know when the 7-year-old was 91 and 93. We need the dates. We need to look at the calendar dates. So, does someone remember? Let's see how Nicole approached this one. Oh, there's dates. Yeah, there's dates. Years are good enough. Okay, we know that Gina and Ava made a statement in 97. Okay, well, let's see here. Fair Lawn reports. Less than a year, victim reported to her paramour. Okay, she didn't get this one right either. The Fair Lawn report, well, listen, let's go. When in doubt, we'll do it together. We'll go to the file. Listen, don't go crazy here. You find when the first time he ever molested a kid, and then look at all the reports, and if there's a new report about one later in time, then you find the latest time that he's accused, and you count the time that passed. Length of time since the last offense. This is an interesting one, too. It's another one that's a calendar one. And you got to look up the date. This one looks at first and last, and counts how long it expired. I mean, if you can find those dates, very, very, very easy. This one, you already found first and last. Now, look at the last, and count from last to today. Now, we did this, the sample I gave you was in 2009 on the video. For our purposes, you look at your watch, you look at your calendar today, you look at your phone, right? If the last one happened in, let's say, I'm seeing the latest dates here. Well, here's the 2002. Let's say something happened in 2002. So, if the last sex act of molestation occurred in 2002. What's today? 2013. That doesn't end it though. So 2002 to 2013 is 11 years. Let's not worry about days right now. It's generally 11 years. Because we only got to worry about 5 or more years, right? So from 2002, the last time he molested, until today, we look at our calendar, is 11 years, right? But you have to subtract any time he was in prison. The reason is, remember, all these things look at risk of reoffense, right? Yeah, it says it.
It doesn't count when you're in jail.
When you're in jail, when you're institutionalized.
Unless in jail, unless you're committing offenses in jail.
Do they count locks by courts?
Yes. And here's why. Think about it. Even if I don't have the answer for you, you can figure out the answer. Risk of reoffense can be evaluated in part by how long you have been at liberty and didn't reoffend. Think about it. I hear defense lawyers come to court all the time. Go, Judge, I know my guy's being sentenced for punching a guy in the nose at a party last year. He hasn't committed an offense since 1996. For 16 years, he's been crime-free, Judge. No, he's not in jail. No, I'm saying that lawyers make the argument all the time. The last time my guy ever got in trouble was 20 years ago. And that's because the time that we are at liberty, we're out of jail, and we don't commit new offenses, says something about us, right? If we commit offense every 6 months, that's a higher risk guy than a guy who hasn't committed offense for many, many years. So one of the factors that is relevant in determining risk of reoffense is how long has a person not molested since his last molest? Think about it for a minute. If a guy molested a kid in 1990, it's 2013 now, right? It's 23 years. If you're trying to figure out, will he do it again? Well, he's got 23 years, but he hasn't done anything. So he's a better risk than a guy who molested again 5 years later, and then 11 years later. So it makes sense that time spent at liberty, that's the critical phrase, at liberty. Time spent at liberty since the last offense has some meaning. It doesn't end the equation, it's only one factor we look at. So the length of time since you last molested somebody is important. A guy who hasn't molested in 6 months, well, you might say, well, what does that prove? Judge, my guy he molested in 1990. It's been 23 years and he's never molested again. He's not going to molest. That has some meaning. 23 years have gone by. That doesn't mean he's a great guy. That doesn't mean he's never going to molest again. But relatively speaking, he spent the past 23 years and he hasn't molested again. That's relevant when you determine risk. You know, all of us did stupid things in college. I know you're in college now. But if you were younger and you did something stupid, you're not going to do that. Now you go, Judge, that was 30 years ago or 40 years ago. You can't use that against me. So much time has elapsed. I'm not going to do that again, whatever that is, because so many years have elapsed. The passage of time without incident is a good predictor. Not a perfect predictor, but it's a good predictor. Now, if you said to me, it's been 35 years since college, I'm never going to do X again. Yeah, but for 34 years, you were in a cage. You were in jail. So that really doesn't tell me anything. Time spent institutionalized, incarcerated, locked down. You're not at liberty. You don't have an opportunity to reoffend. What counts is, I don't want to confuse parole and general incarceration rules, but you can't get credit for good behavior if you were in prison because you had no vulnerability. You couldn't be tempted. It's got to be time at liberty where there was temptation. You couldn't molest in jail. That doesn't prove anything. So what we do is we look at the time from the last offense to today, and we count it. But we have to subtract any time the person was in a lockdown. It's usually jail. Length of time since last offense until today, minus time spent in prison. Do you understand what I'm saying about, let's make it ice cream. I love ice cream. I could eat ice cream all day. If I had a problem with my ice cream eating, and the last time I ate ice cream was in 1990, and they accused me of ice creamery, federal offense, ice creamery, Del Russo, Somebody saw you down by the Dunkin' Donuts. They bought the Baskin Robbins and you went in there to buy ice cream. No, I went in there for coffee, I swear. Judge, have some mercy on Del Russo. It's been 23 years since he last ate ice cream and committed the offense of ice creamery. The prosecutor would say, yeah, but Del Russo's been in jail for 22 years. They ain't got ice cream in jail. He wasn't tempted. You can't say, oh, so he knows that's bad to eat ice cream. He won't get in trouble again. Look, for 23 years, he hasn't gone by a piece of ice cream. Well, that's not very helpful for the judge in determining whether I eat ice cream again. I was in jail. They ain't got no ice cream there. There's no temptation. It has little relevance when you're in jail. So the ice cream for these guys is children. And ain't no children in jail. So you don't get credit for it. Length of time. History of antisocial acts, you count up everything but the sex offenses. Right? Now here, we need to say whether it's 0, 1, 2, or 3, or more than 3. If you look at the risk assessment scale and you listen to my video, that's what it is. We count antisocial acts, and that can include fighting, fire setting, any other offense, truancy if you're a kid. It's not about criminal convictions. It's about antisocial acts. And people who thumb their nose at society, who aren't rule followers, are more likely to reoffend than those who dutifully follow all the rules. Rule followers, less likely to reoffend. Rule breakers, more likely to reoffend. So we look at, are you a rule follower or a rule breaker? We can't count sex offenses, we already counted that. Burglaries, shootings, domestic violence, truancy, fights, all kinds of antisocial acts. We can count down there, because that matters, right? We're looking at, remember, we're trying to balance privacy, right? Privacy with public safety. And we have to narrowly tailor our notification to focus on how risky is this dude? How risky is he? Well, the guy who's got multiple antisocial acts is a greater risk than the guy who's a rule follower. It's as simple as that. Okay, that guy who breaks all the rules is more likely to reoffend. Not because that makes sense, it does, but because there's a legion of research on this. There's lots and lots of research on this stuff. That antisocial personality persons are more likely to reoffend sexually and generally, obviously. Things get a little difficult here with response to treatment, okay? You cannot be scored on response to treatment. And this was a late addition to the videos and audios I posted. This really should be like one thing or connected to one another, because it's really related to number 11. Because therapeutic, this guy was in a lot of treatment. I realize that. AA, this A, NA, TRED reports, psychometric reports. It can get a bit confusing. What we're really concerned about here is whether you're in sex offender treatment.
And he wasn't.
He wasn't, so it would be 0. But those of you who put down he was in this program, that's okay. This requires a little bit more experience applying the scale, okay? Philip's talking about his evaluations. He was recommended for psychiatric treatment. Later, he was recommended for sex offender counseling, but he didn't do it, right? Doesn't look like he did it, but it says here that he was recommended for it. So at the end of the day, we're concerned about whether he's in therapy or not. A guy who's in therapy, right, is less likely to reoffend than a guy who ain't in therapy for sex offending. It's as simple as that. Do we give this guy a gold star? If he's involved? No, but it's a positive act. He's less likely to reoffend than somebody who's just idling away the days waiting for the next kid to walk by. Residential support. If I had my mother or my dad, or I had a sister or brother, or I had family members or a wife, and they said, listen, stay away from ice cream. Where are you going? I'm not going to get ice cream. When you've got people that care about you, you're less likely to reoffend. It's as simple as that. You really are. Doesn't mean you won't, doesn't mean you have power over it, doesn't mean they're going to change the future, but statistically you're less likely to reoffend when people are paying attention, that love and care for you. They call that residential support. Sadly, most of these guys, and especially drug addicts, they have burned so many bridges, they'll never have anyone, because every time someone tried to care for them, the drug addict pulled the rug out from under them, and you reach a point where people just abandon it. But we're not here to worry about that. We're here to look at this guy and evaluate his risk based upon a Supreme Court And one way we do that is look at whether he's got people in his life that care about him. And he lives in a place that's stable and supportive. He's not living in a tree hut in the woods. Yeah.
And he was working with his uncle too, so he had.
Oh, him? I don't know. I didn't look at him. I'm just talking generally. I'm not.
He had his mother and his uncle.
Well, listen, he resides with his mother. You need to look at these things, you need to say them. Well, when you do this kind of work, then you peel away the layers. You go look at it and say, wait, this guy molested 6 times? Where did he live then? With his mother? Well, if he lived with his mother during the 7 rapes, then we can say, well, that is a supervisor, there is a supportive person here, but she's not very potent, she's not very helpful. So, but again, the first order of business is, does he live in a treehouse by himself? Or does he live with somebody who should care for him?
Well,
He lives with his mother.
Jeffrey Dahmer lives in a household filled with love and everything else, and he turns out just as crazy as he was.
No, but he didn't. Did he live with those people when these things were happening?
No, he didn't.
No, I'm not talking about how we grow up. I'm talking about when you are at risk, at the time you're doing stuff. You know, you have to walk past mom to go get the, the hatchet.
But he was killing animals and stuff too.
Yeah, well.
That's not what I'm saying.
Yes.
Quick question.
Go ahead.
I would have to argue that. Because, okay, fine, he's living with his mother all damn day, fine. First and foremost, you don't have any collaterals on her. Secondly, he's working with his uncle, unsupervised, in the community. You don't know who.
Well, we didn't get on employment, but
But you can't say none.
that's a good
because
point.
When you weigh the lesser of the two whatevers, you can't say none because he is. It's just not
Listen, we need to recognize these things. And what's your first name again?
Terry Lee.
What?
Terry Lee.
Terry Lynn. Terry Lynn's saying, listen.
Terry Lee.
Terry what? I'm sorry.
Lee.
Terry Lee. Terry Lee's saying, listen, don't simply look at what it says. Look for the collaterals. Look behind what he's supposed to be doing. And she's right. That's what you need to do. We'll move on to employment. This is another thing that's real important. If you're a drug addict, or you're a sex offender, or you're somebody who commits crimes repeatedly, right? If you're working, you're less likely to reoffend than if you're not. If you're volunteering, if you're busy all day, they say idle hands are the devil's plaything. Right? Now here's a guy, if I'm an ice cream guy, I wake up in the morning, there's nothing to do all day. My thoughts eventually flow to ice cream. If I gotta get up at 9 o'clock and get to work, I can't think about ice cream, These guys, if they're working, you keep busy. The longer you keep busy, the less at risk you are. We're not telling people they gotta work, they don't have to work, this and that. We're just saying it's a fact. If you're busy, if you're working, you're less likely to reoffend than someone who's not working. We're supposed to, the Supreme Court says, look at this guy and assess his risk. And if this guy's working, he's less likely to get in trouble. If he's not, he's more likely. It's a fact. It's research supported. Lots of research on that. Now here's where things get dicey. I got guys that come in and go, my guy's retired. Well listen, he's still home all day. I don't care why he's home, Well, you can't hold it, I'm not holding it against him. I'm just telling you that research tells us that guys who are home, listen, I'm 53, I'm going to be retiring in a few months. I hope I'm pretty, fit, and, I can do lots of damage. But I'm retired. What does retired got to do? I'm retired, man. Do something, Del Russo. Keep busy. If Del Russo ain't busy, watch out for the ice cream. So, education and employment stability, if a guy's in school, that's important. Same thing like working. This really should be called about, number 13 should be the keep him busy criteria. It's a little bit misleading to call it that. Anyway, here's what I'm going to do. Some of you may have recognized things you would have liked to done differently. Some of you may have said, oh, geez, I didn't get that part. What I'm going to do is, you don't have to do this. Anybody who wants to resubmit their analysis, especially because I had to leave early last week, email me. This is one thing you can email me on. Email me. I will delete your submission and you can resubmit it. And you don't have to do that. I'm telling you, I'm going to be very liberal, okay? I'm not going to hold it, I did in the last incident, as long as you're in the ballpark. If those boxes are blank, you're not going to, I don't care what day it is, you should know that. If you're not where, close to where we need to be, you're going to look at points taken off. But if you didn't You know, if your dates are off or you didn't know, you know, those kind of things, I'm gonna be very liberal.
Or
So,
like to add something.
yes, if you missed a kid or something, you know.
Did you score him?
Who?
This
Yeah,
guy,
what
the
did
guy
the
that
score
you
come out
just
to?
curious
You mean
to
Philip?
know what?
No.
Oh, me? Oh, did I do it? What's the score from our office?
Yeah. I wanted to know just to compare.
I'll do the scale too. I'll do it this
Yeah,
weekend.
and post it in the cyber cafe.
I will.
So what if it's-
Watch, I'll get the scale. I'm not gonna, there's a scale on him. I'll find the scale and I'll remove his name. The one that my staff did.
Whoever gets closer to your score, we get extra credit.
You know why? Because there's no right or wrong answer here, I tell you. Man, some people can interpret this. Remember the acquaintance? You may feel strongly that these are acquaintances. I may feel strongly these are predatory.
Yeah.
So you're gonna wind up with a middle tier and I'm gonna wind up with a high
Hey,
tier.
I'm trying to get extra credit here.
Yeah, no, that I don't like. I'm not a big fan of the extra credit, but yes.
So like when I was doing this, I don't remember the reports, but for example, one of the reports, only one of the reports indicated the other brother Lee, who he forced, according to the reporter, to have anal sex with.
Yeah.
So I ended up going back into my scale to say, well, wait a minute.
Because it did say for it.
It said force, but then the whole words and how you use words and the fact that it was in no other report
Right.
made it confusing
Oh.
to say, even though it was alleged that he did this, we don't have anything else to say yet, or more like confirm. We knew what he did with Tabitha because she admitted that stuff happened. So like when you're scaling them, if you have one report that says that this happened, how heavily, I guess, do you weigh?
No, that's an excellent observation. And what you need to do is that word there is conclusory, right? It's force. It's the subjective opinion of whoever said it. I guess the victim said that. So you need to look at what happened, not the characterization of what happened. He forced me. Okay, what happened? You need to go beyond that
But then he said,
word.
like in the report, that he pushed the little boy down, but it was only in that one report.
It didn't go too
It
far
didn't go into
detail.
detail at all.
Okay, listen. So then you can make a finding. I'll put minor physical force.
And then support
And
why.
even if there's 50 reports to the contrary, you know, if you were working for me, I go, good job, you found this. Let them argue that that's not what really happened.
Okay.
But either way, you should all, now, if the kid says, oh, my big brother forced me to have sex, tell me what happened. He told me he's not going to put on Nickelodeon tonight unless I perform sex on him. Okay, what happened next? I performed sex on him. Okay, is that minor physical force or threat? Maybe it's a threat, maybe it's not, but you need to look beyond, you need to see what the guy did rather than what the kid called what he did. And using the conclusory term force, details are what wins the day here. So look at what happened, put the details in a nutshell, one sentence. You know, pushed his head on the bed, Fair Lawn Police Report, 1994, page 11. Okay. Any other questions about this project? Great. We're going to talk more about this in a second.